guys. Hello guys, welcome back with me. Don't forget to like, comment, share, and subscribe. Jones Act Statute of Limitations. When an injury occurs at work, most people need compensation while they recover from their injuries. Fortunately, there are laws that allow workers to file for damage if the injuries happened because of employer negligence. Employers in the maritime industry have the responsibility to ensure workers are thoroughly trained and have a safe working environment. If employees fail to provide these conditions and an injury occurs, maritime workers have the legal right to file a lawsuit against them. However, maritime law under the Jones Act has a statute of limitations that must be adhered to all times in order to have a valid case. How long do maritime workers have to file a lawsuit under the Jones Act? Maritime workers have 3 years from the time the injury occurs to file a lawsuit. It is important to note, however, that not all maritime workers can be filed a lawsuit under the Jones Act. Only seamen are allowed to file for damage under the Jones Act. In order to be qualified as a seaman, the maritime worker must, after 3 years have passed since the accident and injury, seamen are no longer eligible to file a lawsuit for damage. However, there are certain exceptions to the rule. For instance, if the injuries were not discovered yet, the statute may state from the date that they were discovered. An example includes seamen who were injured while out to sea but did not show any signs of harm or suffering from the accident until a year or so later. Seamen working aboard a United States government vessels also have exceptions. Under 46 U.S.C.A., seamen injured while working aboard a U.S. vessel must first submit their claim in writing to the government before filing a lawsuit. In addition, 6 months must pass before the lawsuit can be filed. This provides the government the opportunity to investigate the accident and, if applicable, offer a settlement after the 6-month period is over. Seamen have only 2 years to file their suit. Why is a statute of limitations needed? The statute of limitation is a necessary law that mandates lawsuit to be filed within a certain time period after an injury occurs. The statute of limitations was set into place to ensure that the evidence presented in the case is as accurate as possible. Over time, witnesses may not remember details as clearly and key evidence may be lost or destroyed. In addition, imposing a statute of limitation is lawsuits provides an incentive for plaintiffs to efficiently build their case against the defendant without delay. Statute of limitation may also help to keep fairness in lawsuits. For example, if not statute of limitation is in place, someone who was injured 20 years ago and didn't want to file a lawsuit at the time may decide to start a lawsuit decades later. Additional resources about the Jones Act for maritime workers. If you are loved one who are involved in a maritime injury, we offer you free maritime legal consultation about your rights and options. Fill out our contact form here today. Our lawyers will contact you as soon as possible. Claims process. Hey guys, claims process for Jones Act. If you are a qualified seaman and are injured on the job as a result of negligence by vessel's owner, officers, employers, or a fellow mariner, There are certain steps you must follow in order to file a legal claim against your employer under the Jones Act. For admittedly law, the burden of proof is one of the plaintiff when making a Jones Act personal injury claim. Be sure to follow each step of the process in order and methodically. This process is also time sensitive, so any delay in starting the claims process can reduce your chances of getting a positive result. If you are injured while working abroad, a vessel out to sea or moored at a dock on navigable waters, you must report it immediately to the captain, your employer, or the senior officer aboard. Federal regulations give you a 7-day window to report a work-related injury for Jones Act claims, but it is best to do it as soon as conditions allow. It's also important to seek immediate assistance from your physician, an emergency medical personnel, or your ship's medical officer. Regardless of if the injury seems minor, you need to document everything with medical proof. In many instances, an injury that seems minor may grow to be much more significant. Make sure you have proof of any treatment you received while aboard your ship and request various diagnostic tests. If necessary, if possible, allow the captain to have you evacuate and see if your ship is within range. Even if the injury is not immediately life-threatening, do not try to stay on duty before reporting it. If you take too long in making a report, the vessels or shipping company's insurers will assume you were not hurt enough to justify making a personal injury claim. When you report the injury, make sure that the captain enters in the ship's log. In addition, be aware that the captain, your employers, or senior officer aboard must file a report of marine accident, injury, or death form for federal regulations. File your company-provided injury report as soon as your injuries allow, but make sure you do so when your mind is not under the effects of medication. Be as detailed as possible when you fill out the injury report. Pay special attention to the section about who is at fault for your injury. If you are confused about who caused the injury, it is imperative to seek legal counsel immediately. Okay guys, that's all. Thank you for watching. Don't forget to like, comment, share, and subscribe. And see you.